Yeah.
You know what?
I have no idea what that thing is.
They showed a video. I guess he was upset that CBS 4 guy was like reporting to the team all the guy apparently like 40.
Well,
They're becoming their fans.
hey. Actually, I didn't hear anything about any Eagles fans misbehaving.
It's because they're still in prison.
True. Calm down.
Okay, my computer says 1 o'clock. We have to go by this. Sorry.
Not anymore.
You in a hurry? We have to go by that. Yes.
No.
It didn't have a judge, you know, and then the judge like sitting there waiting.
They did. Seamus McCaffrey.
It looks like it.
McCaffrey, that's right.
So you're gonna do these?
Yes. And this, yeah.
I am not sure. I don't really follow the Pennsylvania judiciary.
Yeah. But you're going to have it. All right. Yeah. Oh, good. All right. Good afternoon, ladies and gentlemen. Will the meeting of January 15th, 2019 please come to order? Before we start on the agenda, we have some introductions. We have 3 new public utility analysts. Amy Willie. Amy, there she is. Renee Edge. And Eric Meese is promoted, so there he is. Welcome.
Promoted to what?
We also have someone who is following everybody today, and Dr. Barua is going to introduce him.
Thank you, Madam Chair. We have with us University of Delaware student, a junior in electrical engineering, Yusuf Ali. Take a bow. It's a program for University of Delaware students to job shadow, and I figured the best way to impress them is in a commission meeting day, so I hope the meeting lasts long today. Thank you, Madam Chair.
Is he only shadowing you today?
He's not shadowing me, I make them the rest of it.
But how long will you be here?
Today.
Just today?
And then we'll have another one on the 31st. Another student.
There is one change to the agenda I would like to make now, and that's under the regular agenda. Items number 1 and 2 will reverse. All right, the first item is the minutes of December 20th, 2018. Are there any corrections, additions, or changes?
Madam Chair, I move that the commission adopt the meeting minutes as submitted.
I second it.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion passes. All right, we have 6 items on the consent agenda. Is there anything that anyone would like to have removed and put on the regular agenda? All right, then may we have a motion, please?
Move we approve the consent agenda as presented.
I second it.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? All right, and now we are on to the regular agenda. First item on the regular agenda is the establishment of the annual motor vehicle dealers assessment for 2019. Mr. Willard.
Yes, we're going to ask the commission to do exactly what you did a year ago on the same issue. We have $15,000 in the fund that's been there for a long time now. We don't feel like we need anything to do this. Statute says that we have to look into this and assess this dealers, but we don't need to have anything assessed now. We already have the money. We just ask you to move the money over to this year's account and ask that you not impose any new fees this year.
Gina? Dana, do you have anything to add?
I do not. Thank you, Madam Acting Chair.
So I ask that you approve order number 9327.
Are there any questions? All right,
Madam Chair, I move that the commission adopt order number 9327 as submitted.
I second.
any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries. All right, and now we're on to number 2 on the regular agenda, which is the matter of the formal complaint of Fishing Inc. against Delmarva Power and Light, disputing disconnect in the amount of the bill. I think we have reversed this so that DP&L will go first, please. Ms. Orr?
Thank you, Acting Chair Conaway and Commissioners. Good afternoon. Lindsay Orr on behalf of Delmarva Power. With me are Agnes Carpenter, Senior Supervisor, and Marianne Murphy, Senior Analyst in the Regulatory and Executive Customer Relations Group, who are available to answer any technical questions that the Commissioners may have. The issue in front of you today arose in the context of a customer complaint case in which a customer who stole almost $110,000 of service has challenged disconnection of their electric service for non-payment. During that proceeding, the question arose of whether Delmarva may transfer an outstanding balance from a customer's previous account to the same customer's current account, and that is the issue the parties briefed and that is before you today. To provide some context, this is not a new issue. As detailed in Delmarva's opening brief to the hearing examiner, on December 9, 2003, the Commission approved Order Number 6328 in Docket 02-231, which approved a settlement providing for periodic workshops involving representatives from Delmarva, staff, and DPA, quote, to continue to monitor the company's performance in customer service areas, including meter reading and billing, end quote. As part of that continued conversation with staff and DPA resulting from the settlement agreement, Delmarva has provided information regarding its procedures with respect to balance transfers and has met with representatives from staff and DPA to discuss those procedures. Delmarva followed those procedures in this case. I don't want to spend too much time restating what is in the papers, but I thought the Commission may find a brief recap of the factual background helpful. Fishing had an account with Delmarva at 434 East Air Street from October 2005 through December 2016. Fishing opened a second account with Delmarva for the adjacent property, 436 East Air Street, in July 2016. A few months later, in December 2016, a Delmarva service person visited 434 East Air Street to disconnect electric service for non-payment. At that time, the service person discovered that 2 of the phases on the 3-phase meter at 434 East Air Street had been diverted, so only 1/3 of the total usage was being registered at the property. After electric service was disconnected at 434 East Air Street, Delmarva noticed that usage at the adjacent 436 East Air Street began increasing dramatically. Delmarva was able to confirm that the entire load that previously had been on the bypassed meter that was disconnected from 434 had been rewired to the active meter at 436. Delmarva estimated the amount of diverted usage, which totaled almost $110,000, and transferred that amount to the open account at 436 East Air Street. That brings us to the legal issue in front of you today, which is whether Delmarva was permitted under the tariff to transfer that balance. Delmarva's position is that the transfer was proper for 3 reasons. First, the tariff provides that a customer who tampers with the company's meter shall pay for the service received but not registered through the meter, but does not specify how the company may collect that payment. Second, the tariff allows Delmarva to withhold service at a new location until an outstanding balance is satisfied. And third, nothing in the tariff specifically prohibits Delmarva from transferring an outstanding balance from a customer's closed account to that same customer's open account. The parties' arguments center around 3 tariff provisions. Delmarva relies primarily on sections 14B and 2D, and staff and DPA rely primarily on section 2C. Turning first to the provisions Delmarva relies on, sections 14B and 2D. Section 14B provides, quote, in the event of the company's meters or other property being tampered or interfered with, the customer being supplied through such equipment shall pay the amount which the company may estimate is due for service used but not registered on the company's meter, end quote. The term shall does not leave room for discretion. The customer must pay the amount the company estimates is due. However, the tariff does not specify exactly how the company may recover that amount. Accordingly, Delmarva should be able to exercise its right to recover payment in this instance in any manner that does not violate the tariff, and the tariff does not specifically prohibit Delmarva from collecting for the used but unbilled service from the same individual at a different service location. Not only is this action not prohibited, but it is in line with the spirit of Section 2D. Section 2D provides that when an existing customer seeks service at a new location, Delmarva may withhold providing service until the customer has paid for any and all service the customer received at any other location. In this case, Fishing opened a new account with Delmarva at 436 East Air Street, just months before Delmarva discovered the theft of service from 434 East Air Street. Had Delmarva discovered that theft of service a few months earlier, it would have been indisputable that Delmarva could have prevented Fishing from opening the account at 436 until it had paid for the used but unbilled service from 434. The passing of a few months should not override the intent of the tariff to require the customer who tampered with the meter, rather than Delmarva's other customers, to pay for the usage derived from the meter tampering. Staff and DPA focus on Section 2C of the tariff, but take that section out of context. Section 2 addresses application and contract for service, and subsection 2C is titled 1 point of delivery. In context, that section provides, quote, "The service classifications of this tariff, unless otherwise stated, are based upon the service to one entire premises through a single delivery and metering point. The company shall provide only one metering installation for each class of service. The use of service at 2 or more separate properties shall not be combined for billing purposes." This section means Delmarva must deliver to only one point of service at a premise and has nothing to do with transferring balances. If Delmarva is already delivering to one point on the property, it is not required to deliver to another point on the same premise under the same rate class. The specific language that use of service at 2 separate properties shall not be combined for billing purposes simply means that if a customer has houses on 2 separate properties, it will receive bills for both properties. It does not prohibit Delmarva from collecting an unpaid balance from a previous account by transferring that balance to another account held by the same person or entity. The hearing examiner agreed that this language is not exactly on point in the context of this case. In his findings and recommendations, the hearing examiner discussed Delmarva's arguments with respect to Section 2D and discussed staff and DPA's arguments with respect to Section 2C. The hearing examiner found that neither provision was directly on point, but stated the provisions cited by staff and DPA was close. The hearing examiner did not, however, address Delmarva's arguments with respect to Section 14B, which requires that a customer who has tampered with a meter shall pay the amount which the company may estimate is due for service used but not registered on the company's meter. This provision seems to be the most relevant of the 3 cited to this case because it addresses meter tampering. Delmarva respectfully suggests that Section 14B, which provides that a customer who tampers with the company's meter shall pay for the service received but not registered, in combination with Section 2D, which provides that Delmarva may withhold service at a new location until the customer has paid for all service received at any other location, is more on point than Section 2C. The hearing examiner did not address the effect of these 2 provisions in combination. The tariff gives Delmarva a right to recover the amount it estimates is due for service stolen through meter tampering, but does not specify how Delmarva can exercise that right. This is not entirely surprising, as no tariff can possibly specify every single action that a utility may take in the course of its business. However, Delmarva's actions in recovering the amount owed by Fishing were in line with the spirit of Section 2D, which allows the company to recover an outstanding balance from a customer attempting to avoid payment of that balance by moving service locations. This makes sense from an equitable perspective, as it is ultimately Delmarva's customers who pay for stolen service through rates. If Delmarva is not permitted to collect the amount owed from Fishing, that amount will go into the uncollectible debts of the company, which in turn negatively impacts ratepayers. The fact that Fishing fraudulently consumed energy should not fall to the ratepayers who legally obtain and pay for services. In sum, Delmarva's actions here were reasonable, consistent with the letter and spirit of the tariff, and designed to recover for stolen service. Accordingly, the fair and reasonable interpretation of the tariff in this case is to allow the balance transfer. To rule otherwise would, in effect, reward fishing for its theft at the expense of both Delmarva and its customers. Accordingly, Delmarva respectfully requests the Commission reject proposed Order 9320. Thank you.
Any questions?
Thank you. Thank you, Madam Chair. In the context of the tariff, if there is meter tampering, who pays for the electricity? Is it the owner of the meter from where the electricity has been diverted? Or is it the recipient of the electricity where the diversion has targeted sending it? I'm sorry, can you repeat that one more time? So you have two properties. One you were sending power to, and that meter is typically billed if the power goes through the meter. In the case or scenario where that power is diverted to another destination, does the tariff identify who is responsible to pay for that power, the intended recipient or the target that where the energy was consumed?
I believe, Your Honor, that it would be who benefited from the service.
Well, it could be in this context, both parties were in some way benefiting, depending on how you define benefit. What I'm trying to determine is, if you interpret the tariff, is it the person who has the meter that you expected would receive the power, or is it the person who received the power that is responsible to pay for the power?
Well, in this case, Commissioner, it would be the same. There's only one party, which is fishing, that had two accounts at two adjacent properties. And so they both were intended to receive the service, but diverted 2 phases of that to another property.
So
I may be getting mixed up in the technicalities. I don't know if either Ms. Carpenter or Ms. Murphy want to jump in.
Let me give you a slight twist on the scenario. What happens if they are not related parties? And in the case where you were intending to give the power to customer A, who has a meter, but customer B received the power, who's responsible for paying for the power?
I would want to review the tariff specifically for that scenario in order to respond to that question. In this specific circumstance, as I mentioned, it was the same customer, which is why I did not focus on the specific example that you're providing. So I don't know that I could answer that question just off the top of my head.
I think I can.
I think I can too. If I live in a house and I'm getting electricity and I'm not sure exactly how that diversion works, bringing it from one building to another, but if I have a meter at my house and either my next door neighbor steals it or I run something of bypassing the meter into my next door neighbor's house, who is responsible for paying for that electricity? Am I, who have diverted some of my electricity before the meter to my next door neighbor, or is my next door neighbor who was the recipient of that, illegal diversion of electricity?
Under Section 14B, the person who tampered with the meter is responsible to pay for the amount that was diverted.
That may be my next door neighbor who, unbeknownst to me, diverted electricity from me. So that's even more difficult to determine who actually did the tampering.
Well, what if you can't find a tamperer? The question still remains.
Well,
And
with all due respect, I'm just confused as to what question we're trying to, in this case, there was one customer that both diverted the electricity and benefited from that diversion.
We may get to that point in this discussion, but right now the question is, I've got two places where the power can land. And I'm trying to determine, in the case of a diversion, does the tariff guide us as to who pays for the power?
And I may have been explaining the technicalities of the diversion wrong. I understand that the diverted usage was not registering on the meter in this case,
I
on any
understand.
meter.
I understand that.
Yep.
But ultimately, Delmarva is able to discern that more power was sent between those two destinations. And at the end of the day, if they are unrelated parties, my question still remains, is it the person whose meter the power was intended, or was it the person who gets the power in the end who winds up responsible for paying for the power? Same question.
May I defer to my colleague to I think answer that question? Thank you.
So anytime a customer is diverting usage and it's not measuring on a meter, okay, we are looking to recover the energy, the stolen energy, from whoever benefited from that service. So whether that be the person that actually set up an underground tap or the diversion, or a person unknowingly that benefited from the service and received stolen energy. We are just looking to recoup the amount of energy from whoever benefited from that service.
I think, Madam Chair, I saw a public advocate who might provide a little context, if I might ask for her to weigh in.
And before you do, may I specifically, that question, but in concert with that question, I think, is the question of two billings or one billing. It comes down to the billing, really, too. We're talking about the same, we understand it's the same customer, but it's the billing of that disputed amount. And the important thing is whether or not, I guess, two things, who's going to pay for that? Who's going to pay for each bill? And is this electricity going to be turned back on again, if in fact it's not turned on right now? So.
Okay, thank you. This is Gina Iori on behalf of the Public Advocate. I do have an argument prepared, but with respect to the questions that Commissioners Gray and Drexler have been raising. First of all, let's assume, and I think this was implicit in Commissioner Gray's question, you have two separate premises. Both of those premises receive two separate bills. If someone is diverting energy to another premises, assuming, and we can't, I'm going to assume it for purposes of your question because there has been no evidentiary hearing in this case, and there has been no determination that there was any theft of service. But let's assume for purposes of your question that there was a theft of service. If the theft is such that the energy is being diverted to another premises to which electricity is also being supplied, customer B is going to be billed for it, and assuming that they pay their bills timely, is going to be paying for it. As between the two of those, I mean, in that case, it doesn't matter to Delmarva, it's getting paid. So for it to then go back and go after customer A for all of the money would be a double recovery to a certain extent. As between customer A and customer B, who should be liable for or responsible for that, clearly it's customer A. But under the hypothetical that I think Commissioner Gray and to a certain extent you, Commissioner Drexler, were raising as well, as between, with Delmarva, if Delmarva's being paid, they don't have an issue. They are being paid. Now, customer B could find out that that there's been a diversion, that he's been paying for customer A's electricity, but that's between them.
So, thank you for that input. That brings to me,
Commissioner, may I add to that just briefly, because I think it would help clarify this a little bit. The account, once signed, becomes a contract, so we've got contract principles that would come into play here, which are really not part of, I would submit, this hearing insofar as there's any exception to the hearing examiner's report. It's really just on the issue of the lawfulness of the transfer. With that being said, in that scenario, once you get into, under the hat of it being a contract, then you have quantum merit and unjust enrichment arguments as between the two customers. And here, you mentioned could be both parties. The difference here is that there are, and I believe this is in the hearing examiner's report, there are two accounts, and therefore two customers, and therefore two contracts. That's what the DPA and staff argued. So that's at a different level as between those two parties, and you get into contract arguments. And if Delmarva is to have a loss there, and they've identified it, whereas here in 2010 they had pictures of this diversion, or knowledge of the diversion, I should say, then you get into other contract principles such as a duty to mitigate. And there are statute of limitations that come into play there as well. Because it's a contract, Delaware code tells us that it's a 3-year statute of limitations. So we're on another playing field with a lot of different contract principles in play. And I think it would really depend on who is suing whom, and whether there were a third-party action. Because if I was sued by any company and what I'm paying for is being diverted to somebody else, then I'm filing a third-party complaint against that person as part of my answer for unjust enrichment. And they are picking up that part of it, plus any damages that I might incur as a result of the diversion. So that's where that would go. But circling back, again, I think we're getting far off the track of, respectfully, of the exceptions to the hearing examiner's report. The Commission's rules, 2.19, specify what is entailed in exceptions to hearing examiner's reports, and it's not to re-argue before your honors the underlying case, but to look at the hearing examiner's report and determine whether it meets the same standard that an order from this commission would be held to, and that is a substantial evidence standard. So I think that's where we are here today.
okay, thank you. Well, I understand the Commissioner Examiner's report, and from the testimony at Delmarva, I'm simply trying to get a picture in my mind based on the tariff, which I don't understand perhaps as well as some of you folks do. If there is guidance on a diversion and who pays. But I did hear, I think, in some of your testimony, Ms. Ross, that you said that the diversion from 434 was to 436 air and rewired to the meter at 436. Is that an accurate statement, rewired to the meter? Because if it's rewired to the meter, then it would seem to me that the billing is being tracked at 436. Or did I misunderstand something?
Well, it's my colleagues to my right are much more in tune to the technical language than I am, so it's possible that I misspoke. So I would ask if one of you want to jump in to make sure I characterize that correctly.
Yes. To clarify, the meter at 434 was actually being bypassed. It wasn't being diverted. One meter has 3 phases. 2 of those phases that connect to that 1 meter were being diverted, so only 1 phase of that usage was being billed. That usage was not being sent to another meter, so it wasn't being registered at 436.
So the statement I heard, which I wrote down, is not an accurate statement? That it was
Yes,
not
it was a-
rewired to the meter at 436?
Right, there was an incorrect use of terms because it was bypassed. It wasn't being diverted to a different service. It was being diverted from registering on that meter at 434.
And diverted around the meter at 436
Yes.
as well? Okay, so
Yes.
this helps me to gain a context, because if your statement was accurate that it was rewired to the meter, then I would have to assume that the meter would be read by Delmarva, and it would be a whole different set of decision-making here at the commission. So, Madam Chair, I have no further questions.
A quick question. So the diversion from 434 to 436, you're saying 2 phases of the 3 phases were disconnected?
Yes.
It wasn't that, it was, I don't even know how it works, but a wire was being sent to was 436 the beneficiary of that, or 434? And if 436 was the beneficiary of that, how was it the beneficiary if it wasn't being sent over, the electricity? Or was it just that 434 wasn't paying for the amount of electricity it was using? My question is, how did 436 benefit from 434 diverting 2 phases of its meter?
And to make it even clearer, the usage that registered at 436 was after the fact. That was the only reason the company is bringing up that the usage was diverted from 434 to 436, meaning it was rewired after the service was disconnected, was to base our billing adjustment on 434. So the usage at 436, essentially 2 phases of that 3-phase meter weren't being recorded anywhere. It was being consumed at 434. The customer was benefiting from 100% of the usage, but only 1/3 of that usage was being recorded. The company brought up the point that the metering was rewired. The internal wiring was rewired from 434 to 436, and that's how the company was able to base our adjustment based on the increase in usage.
Commissioner Korean?
Am I correct in assuming that 434 and 436, both the meters were being billed under one tariff, commercial rate? Am I correct?
Yes, they were under the same rate,
Yes.
right? Yes, 434 and 436 were under the same rate, yes.
So if both the rates are same, except the demand charge may be different because 434 might have 10 demand and 436 might have 12 demand. So the difference of the demands will come into the play? Am I correct into that also? Will you bill them higher demand if 436 had a higher demand when they came to open the account with you? Each building has a different demand, right? This building's demand charge.
It's based on the amount of usage.
Right, so 434 and 436, did they both have same demand on your records, on your accounting, or they have different?
The demand for the adjustment was our electrical engineer actually took into consideration the hourly usage to determine the corrected demands for the adjusted period for 434.
And the last question is, if this order is rejected by the commission as you are requesting, how will you collect the money, number one? And if they don't pay, it's only one customer, not 2 customers. If they don't pay, will you shut off 434 and 436 both? Or only
434 and 436 are both already disconnected. 434 was disconnected in 2016. That's when the issue of the bypass meter was discovered, and then 436 was disconnected earlier this year, which is what prompted the filing of the customer complaint.
Right. So then the next question will be that will you take the company to the court? If they don't pay you, what will happen?
Well, if the commission rejects the hearing examiner's order today, I would think that the next step procedurally would be to remand to the hearing examiner to continue with the customer complaint. We haven't gotten to the issues yet of the actual disconnection. We've been focused on this balance transfer question arose. We paused for briefing, but we still have not finished the customer complaint case in the sense of, was notice given of the disconnection and those types of things that need to be established. So I would think that would be the next part in the process.
See, both the meters are disconnected. Am I correct in presuming that the business is closed?
I
Or
don't-
at both buildings?
I don't know what the status of the business is. I don't know if that's in our records. I don't know. I know that when we have sent mail to the address that was provided in the complaint as the complainant's mailing address, that mail has been returned.
Okay, thank you.
Okay,
Thank you.
Ms. Iori, would you like to?
Thank you, Madam Acting Chair and Commissioners. There's been a lot of talk about theft of electricity. Delmarva wants you to believe that there has been theft of electricity, but I cannot impress upon you greatly enough that there has been no determination that electricity was stolen. None. We have not had an evidentiary hearing, so the hearing examiner has not made that decision. And Delmarva, although there is a criminal statute that allows it to bring criminal charges against a customer that it suspects has stolen electricity, Delmarva has not chosen to do that. Now, they say it's expensive to do that. That is not the issue. And that opportunity is available to them, and they have not chosen to do it. So for purposes of what is before you today, I cannot stress strongly enough that you cannot consider any theft or non-theft. That is not what the question that the hearing examiner posed to the parties and which the hearing examiner answered. For purposes of what the hearing examiner considered and what the parties addressed in their briefing is only the balance transfer issue. So, I know that it sounds ugly, and sometimes bad facts make bad law. We hope the commission won't let those bad facts lead it to make a bad decision. Now, the DPA is involved in this case not to protect this customer, but to protect all Delmarva customers, because this balance transfer issue has been a thorn in its side. You heard Ms. Orr say, well, back in this docket, we agreed that this would happen. There's still nothing in the tariff, and that is what needs to guide the commission's decision, because it is the tariff that the customers and Delmarva are required to follow. The tariff is the contract between the customer and Delmarva, not some agreement that staff and the DPA may or may not have made 15, 20 years ago. Now, Delmarva agreed that the question before the hearing examiner was this: can Delmarva transfer an outstanding balance from a customer's one account to that same customer's other account, which it says it did in this matter, and then disconnect service to the transferred account for non-payment of both the current and transferred balances? Now, the facts are essentially undisputed. Fishing had an account at 434 East Air, that's A-Y-R-E Street, and took electricity at that service location for several years. Although there has not been an evidentiary hearing in this case, Delmarva has presented certain, quote, facts to you. Let me present another fact to you. During most of the time that fishing was taking service at 434 East Air Street, there was some other customer taking service at 436 East Air Street. So it is not that both fishing was taking service at both 434 and 436 at all times relevant to this proceeding. Fishing didn't begin taking electricity at 436 East Air Street until July 2016. Apparently, there was an outstanding unpaid balance at 434 at the time that they sought to take service at 436. Now, Delmarva could have, you assume that Delmarva would have known that at the time, or it certainly could have checked it at the time they signed fishing up at 436. They did not. So, after fishing did not, you've heard why Delmarva thinks it was appropriate to transfer the balance, blah, blah, blah. And after fishing didn't pay the combined amounts, Delmarva disconnected the service at 436 East Air Street as well. Now, the hearing examiner based his decision on Delmarva's tariff provisions, and he determined that the tariff provisions on which Delmarva relied here do not permit Delmarva to do what it did. We suggest that the hearing examiner got it right. First, he found that the tariff provision that allows Delmarva to refuse to provide new service to a customer with a previously unpaid balance did not help Delmarva here, because Delmarva did not refuse to connect fishing at 436 Air Street based on the existing unpaid balance at 434 East Air Street. Delmarva is trying to bootstrap an amount owed at 434 East Air Street, is trying to bootstrap the tariff provision that allows it to refuse to provide service at a new location. It didn't do that. And you have to take the facts as they are, not the facts that Delmarva wishes they were. Rather, it went ahead and connected 436 without seeking to collect the outstanding balances from 434 East Air Street before connecting 436. The hearing examiner also rejected Delmarva's contention that it was unaware of the meter tampering at 434 when it connected 436. Again, pretty much the same reason. The hearing examiner agreed with staff and the DPA that Delmarva's awareness or not of this fact was irrelevant because the parties must take the facts as they are, again, not what they want them to be. The hearing examiner also rejected Delmarva's reliance on these alleged agreements, finding that the correspondence didn't overcome the tariff language. While it is true that the hearing examiner didn't completely accept staff and DPA's argument that the definitions stating that the use of service at two or more separate locations shall not be combined for billing purposes precluded Delmarva from transferring an outstanding balance from one account to another, but he did call it close, quote, close, and quote, it certainly seems to suggest a requirement of keeping different accounts to the same customer separate, end quote. The hearing examiner did agree with staff and Delmarva that Section 2D of Delmarva's tariff, on which Delmarva primarily relied, to support its transfer of the alleged outstanding balance did not justify its action. Rather, he found that Delmarva's contention that the language permitting Delmarva to refuse to connect a customer with an outstanding unpaid balance supported its right to transfer an outstanding balance from one account to a separate account was, and I quote, a stretch. He found that Delmarva's tariff definitions of customer and premises supported staff's and DPA's contention that Section 2D, on which Delmarva relies, did not authorize balance transfers from one customer account to another account of that same customer. And he concluded that absent specific tariff language permitting balance transfers between customer accounts, Section 2D did not give Delmarva that authority. He found this especially true given the tariff language that suggested that accounts are to be considered separate. Now remember that Delmarva drafts its tariff language, and those terms and conditions are non-negotiable. A customer can't say, well, gee, let's talk about this. We'd like to have this provision instead. You can't. It's the tariff or nothing. Tariffs have the same effect as statutes and are construed using the same rules of construction. So if the terms of a statute are ambiguous, that's on Delmarva. It's not on its customers. And Delmarva can't add language to a tariff that isn't there. So if Delmarva wants to be able to transfer balances between customer accounts, it should seek commission approval to do so. And depending on what Delmarva proposes, the DPA may or may not oppose its proposal. But unless and until the tariff is modified, it does not have the right to do what it did here. And the commission should not sanction this impermissible action against this customer or any other customer by rejecting the hearing examiner's findings and recommendations. The DPA respectfully submits that the commission should adopt the hearing examiner's findings and recommendations. And if the commissioners have any questions, I hopefully will be able to answer them.
Commissioners? Okay.
You go.
Ms. Iyer, you mentioned about criminal action because theft is a criminal thing. This is a civil or is a contractual thing with the tariff and everything. Am I correct?
I'm sorry?
You had mentioned that Delmarva or any electric company can file a lawsuit against criminal complaint against the guy who steals the electricity.
Correct.
It's a theft.
That's not in the tariff. That is in the
Right.
statutes.
That's a separate, yeah.
It
That's
is a
criminal.
statute, but it is a remedy that is available to Delmarva that it has not pursued.
Right, that was my question. Then have they filed any criminal complaint?
It has, as far as we know, it has not.
That was my question.
But
Okay.
it has done that in the past. And I specifically recall another alleged customer theft where Delmarva did, in fact, take that customer to court and was successful in getting a judgment against that customer.
Thank you.
Commissioner Drexler?
And so the order states that if we do accept the hearing examiner's findings, that what will happen next, the next steps are that Delmarva will send a bill to 436, to the owner of 436, in the amount of approximately $5,000 past due. The customer has 30 days to pay that, 31 days or 30 days to pay that. And if that is not paid, that electricity will not be restored. But if there is some dispute, billing dispute, that it must be turned on immediately. But if the billing cannot be combined, the alleged theft of service really goes back to 434. Correct me if I'm wrong. So there wouldn't necessarily be a billing dispute any longer on 436 because it would be the billing from the period 12/2016 through the current time when the amounts were past due. Is that correct, Ms. Iori?
I think that's correct, yes.
So another question.
The dispute would relate to 434
Right, because it contends.
and the alleged theft.
That you cannot combine, so the theft question and billing, the billing question and theft of service would then go back to being a court matter theoretically or potentially relating to only 434.
That's
I mean, if you
correct.
take 436 as a separate entity, power was restored there in 2016. The bill is past due in 2019. If there's a billing dispute there, it's a separate billing dispute.
That's correct.
And that is what it will be, the subject of the order, whether or not that gets turned on.
That is correct. The billing, the theft service allegation relates only to 434.
One question, again, for Delmarva. So if we assume that the allowance or connection of 436 instead of denying them a connection because of the 434, is there something that Delmarva is doing different now that will prevent us from getting here again in the future?
Is there something, I'm sorry, is there something that
So-
Delmarva is doing different in terms of?
436 was allowed to connect, while 434 that you defined as the same customer was apparently either delinquent or somehow not current. So my question is, if they got the connection at 436 in their scenario, what's being done differently today that'll prevent us from getting here with someone else in the future?
Well, Commissioner Gray, I was actually going to ask for a chance to respond to Ms. Iori's comment in that regard. At the time that the application was made for service at 436, which was in July of 2016, there was no significant outstanding balance at 434. We have since learned that Delmarva did not discover the bypassed meter until December of 2016. There may have been some small outstanding balance because by December, they were scheduled for disconnection for non-payment. I don't have those specific numbers with me, but it's not the case that there was a significant outstanding balance and Delmarva opened the account at 436 anyway. So I'm
sorry, I thought you were finished.
no, I was just going to say, so I don't know what there would be, what process would need to be changed in that regard.
May I address that question?
Excuse me just 1 minute. On page 12 of order number 9320, in paragraph 5, it says Delmarva admits that when it searched its records at a later date, it uncovered 2010 photographs which allegedly showed the meter tampering.
Yes, there were photos taken of all of the meters that were exchanged in 2010 during AMI, but those were not analyzed in the context of this dispute. So I apologize if my statement was misleading. There was a photograph from 2010 showing this, that once this case arose, Delmarva went back and reviewed and saw that that was the beginning of the tampering, but no one at Delmarva was aware when the application for service was made at 436 that there was this bypassed meter at 434.
And yet they were both accounts under the same name.
Yes, both accounts were under the same name.
Thank you.
I have a question.
You have a question?
Ms. Ivory, did you find in your work that Delmarva had taken the deposit from the commercial customer at 434, same company, 436 also? Are there two deposits or one or none?
I don't know what Delmarva did with respect to the connections,
Okay.
whether they would require a deposit or not.
Okay.
But that really isn't
No, that's
the
not
point of,
Yeah.
that's presented
Yeah.
to us. I wanted to address Ms. Orr's comment that there was no, quote, significant outstanding balance. Again, we have not had an evidentiary hearing in this case, but the fact of the matter was there was an outstanding balance. Significant can be in the eye of the beholder, but there was an outstanding balance, and Delmarva could have refused to connect 436 until that outstanding balance at 434 was paid. It didn't, and that is the point.
Do you have another question? Okay. Mr. Walsh.
I have, as you know, Your Honor, DPA and staff filed jointly in this, and I just want to reiterate that we're getting beyond the core issue here, and that is the hearing examiner's report, which goes into great detail as to the issue of the transfer, and his decision on that renders the theft part, alleged theft part, I should stress that. I've heard it enough today that I'm starting to just use it, but it's an alleged theft, which is not within the jurisdiction of this commission. That's a key here. And that is why the issue arose. There was an agreement that Delmarva could have denied service at one point. But that became irrelevant when it did not. What is relevant is, can it transfer that issue of the alleged theft and that outstanding balance, consolidate it over here, and then disconnect based on a consolidation that includes the allegation. That's the core issue here. And the hearing examiner substantiated all of his findings based on the facts and the law. And I join with DPA in asking the commission to approve the order.
Any further questions?
One last question, Madam Chair, for Delmarva. So I know sometimes when you're looking at the definition of customer versus account, especially in IT systems, these things are multidimensional, and sometimes they're collapsed or rolled up. But it sounded to me as though account and premise or the destination of the power have a one-to-one relationship. Is that a good statement to the meter?
A one-to-one relationship to the meter, that's
Yes.
accurate, right? Yes.
So that would make the separate premises distinguishable and different, yes?
Yes.
And has Delmarva combined accounts for billing purposes with other customers?
We have not, if I'm misstating the technical, I ask my colleagues to jump in. I don't believe that we have combined the accounts in the sense that the 434 account was closed. They had different account numbers, but we transferred the balance or the amount that would have been due from 434 to 436. Is that accurate?
Yes, so each premise, each meter is billed on its own. So one customer could have multiple accounts servicing multiple premises. While those services are active, they're not combined, they're not, 436, 434, you're not receiving one bill. If there's 2 meters, there's a bill for each metered service. So the bills are separate up until the account becomes inactive, and then if the balance is unpaid and the customer had active service under the same name, we would move that inactive balance over to the active account to obtain payment.
So yes.
Thank you, Ms. Iori. I have no further questions, Madam Chair.
So I move that we adopt order number 9320.
I'll second.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Thank you very much. Motion passes. All right, and now we are on to, are there any members of the public who would like to make comments? Public comments. There being none, we're on to director's comments. Dr. Barua.
Thank you, Madam Chair. The next commission meeting is going to be on January 31st, 2018. I do not have any other comments. At this time, I'm going to ask everybody leave except for staff. I request that the commission go into executive session so that it can receive legal advice from our counsel.
May we have a motion, please?
So moved.
Second.
All those in favor? Aye.
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 Any opposed? Any abstentions?